Okay, so today is August the 14th?
15th.
15th, okay, August the 15th, 2012. We're at the Hyatt Regency Maui, and we're here to interview Judge Peter Bowie in a brief video oral history to supplement a longer, more complete oral interview that we would hope that you will take in the near future. I'm Geraldine Mund, and I'm here on behalf of the Ninth Judicial Circuit Historical Society. So, Peter, well, I know that you went to college in the East, where you were born, and then you went in the Navy, as I'm sure you had no choice at the time about military service, but you may have looked forward to it, I'm not sure. And then you came back and you went immediately to law school, correct?
Correct.
And then you went to work in the Civil Division of the U.S. Attorney's Office?
No, I went initially to the Justice Department under their honors program and was recruited back there and had almost 3 years back there, tried more cases in those years around the country than I'd tried before, worked on special projects, one specifically with L. Patrick Gray, who was the Assistant Attorney General at the time and then became the head of the FBI. Working on a civil substitute for the exclusionary rule, that kind of thing. Yeah, it was pretty heady stuff back then. I had done very well in law school, and that gave me a number of options. I'd been a lawyer for 2 months when I tried a 3.5-week case in Detroit with a co-defendant with a jury and so on. I chaired an interdepartmental task force to come up with an approach for how we were going to handle no-fault legislation, because the government under the Federal Tort Claims Act is liable as a private person would be under the law of the place where the act or omission occurred. I mean, just the number of postal vehicles we have on the highways, as an example, or all kinds of government vehicles, that kind of thing. If we're subject to no-fault legislation in various states, it's going to be so inconsistent wherever it is, trying to figure out what the answer ought to be and how we ought to deal with it as an institution. And I got to chair that as a rookie lawyer. Probably the biggest kick, though, was being sworn into the California bar by William O. Douglas, who was the supervisory justice of the Ninth Circuit at the time. And it was so much fun because he reserved the West Conference Room, had 4 of us there, justice lawyers that he was swearing in, flirted with the wives, posed for pictures, that kind of stuff. It was a kick.
And so you were always still working on the civil side, not the criminal side?
I worked on the civil side exclusively there, and then the travel was brutal. 73, I was gone over 200 days in working cases all over the country. My wife said, that's enough. And when our daughter was born, I wanted to be around to watch her grow up, and an opening came in the U.S. Attorney's Office in San Diego, and I applied for that. I'd gone to law school there. I'd been in the Navy in San Diego. And so I applied for it, although not thinking I was going to get it, got it. And I thought I was going to go into private practice with 2 of my classmates from law school, both of whom became judges. But I started having so much fun. The quality of the work was just immense and so rewarding that I didn't leave until 14 years later when I went on the bench. The last 6 of my years at the U.S. Attorney's Office, I was the number 2 in the office, the chief assistant, and overseeing both criminal and civil.
So what was the quality of the work? Why do you say it? What was special?
Well, it was just really rewarding. I'll give you an example of one of the categories of cases. Somehow I got tasked to deal with the Marine Mammal Protection Act enforcement. San Diego was a home port for the tuna industry at that time. And there were lots of problems coming up because the tuna boats were setting the purse seines using the porpoise to find the tuna underneath, and would set these big purse seines, and then the porpoise would get caught in the nets and drown. And some skippers were a lot more concerned about that and working harder, even at risk of the crewmen and that kind of thing. But it ultimately led to putting observers on the boats. It led to enforcement in other ways, such as seizing the catches when they came into harbor and then negotiating with them for the penalty because of the amount of porpoise once they exceeded the quota, arguing a case in the Ninth Circuit with Justice Kennedy, then Judge Kennedy on the lead, on the propriety of this, and it was a unique experience in San Francisco because the government was in the middle. The environmentalists were saying, you're not doing enough, and the industry saying, you're strangling us. The courtroom was packed. It was an emergency expedited hearing, and went for an hour and something, and they took 15 minutes and came back and ruled for us. And then of course the press is all over everybody, but and it was mostly press in the courtroom. But it was that kind of really rewarding opportunity to be involved in something that has an impact.
Had you had any bankruptcy-related cases while you were in the U.S. Attorney's Office?
Almost none. That was in the pre-code days, and all you had to do in those days, government had an absolute priority. You walked in and say, I represent the government, and nobody could do anything till they settled with you. So you didn't really have to know anything except that much. So no, I did not have a bunch of bankruptcy experience. I had civil litigation experience, and including a number of trials and that kind of thing, but no bankruptcy.
So 14 years, and all of a sudden you became a bankruptcy judge. What happened?
Well, there was a group of new judgeships, as you would remember, that were approved in about 86 or 87, something like that. And I got a call from Jim Myers, whom I had known from the time I came to the U.S. Attorney's Office in San Diego. We were not close friends at the time, much closer now actually, but he was very good friends with another person I had worked with in the U.S. Attorney's Office, and he called and said, the circuit's getting ready to announce a new position. I think you'd like it. I'd suggest you take a look at it. The governor's people had talked to me about the local people, not anybody close, but about a possibility of a state court position. Every time I looked at the state court, it was such a circus over there. I just didn't want any part of it. But I took a look at this job, and what I love to do is play with legal issues. That's the most rewarding thing to me. And when I saw that it was really a law and motion practice and an independent calendar kind of system, even though the substantive law was something with which I was not familiar, basically, that the way it worked really appealed to me. So I applied and was very fortunate in getting the position. And it so far exceeded my expectations. It really did. It still continues to. Had some unique opportunities, but just coming to understand that bankruptcy is different than most everything else because it's an umbrella. Normal litigation is you sue me out of a single act transaction or occurrence. It may be a phony prospectus or a prospectus in error and affecting millions of people, or it may be a slip and fall on the sidewalk in front of my house. But single action transaction or occurrence, bankruptcy is the umbrella. It brings the universe, the economic universe of a debtor into the arena, and we have to sort out what a debtor's rights and responsibilities are under non-bankruptcy law, and that's real general kind of stuff and exciting, and just so enriching, and I just love learning. So
you took the oath, you came on the bench, you didn't know anything.
Right.
Yeah. Here's a blue book. This is the code. Mm-hmm. What was it like?
Well, my colleagues didn't go through and gather up the barking dogs and pass those to me. Instead, what they did was they had cases that were ready for trial. And they would assign me those cases, and I would take them and try them because that was my basic background, was as a trial lawyer. And so I got to learn in bits and pieces, almost interstitially initially, about the code and the rules. But much of the rules with respect to litigation are the civil rules, with which I was familiar. So, I mean, there were a lot of late nights and long weekends and that kind of stuff in terms of learning. But that's what I wanted. I wanted the challenge of continuing to learn. And I mean, I still like that 24 plus years later, but that was really rewarding. I was behind the curve for a while, I think. But because of the way they handled my introduction, if you will, to the court, I never felt buried or in a hole that I couldn't find my way out of.
Now, when you came on, that was a 4-judge court.
Yes, I was the fourth.
You were the 4th. And what's it been like to be in that court?
Well, our court has been an incredibly collegial one, as you know. When I came on board, Jim Myers was the chief, Louise Adler was next in seniority, then John Hargrove, and then me. When Hargrove left, up until that moment in time, which was about my 19th year on the bench, I was still the junior judge. But by then I'd become chief, so I no longer had to hold the door when we were having ceremonial functions. And actually, he had to do it, up until the time he left. So, the stability on that court. And so we'd work together, all of us together, in a small court, little islands, if you will, each of our own, because we don't always see everything substantively the same way, but we work together well, I think. And so I found it very, very rewarding. It was actually never my objective to become chief. I proposed to pass on it because I like working cases. I had spent 6 years as chief assistant, as I mentioned, and I'd had my share of the administrative stuff, and it's not my favorite thing to do. You can never please everybody in that kind of a role. But I was persuaded to accept being chief because a lot of our district court judges are old friends of mine from the U.S. Attorney's Office days, and we've remained friends, and they felt, particularly since we'd be filling some new positions, having good relations with the district court and the chief district judges and so on would be beneficial to that process, and so I've done it.
What cases that you've had stand out in your memory?
Oh, heavens. There are all kinds of them, but I'll start with my first two, because that really opened my eyes to what I was getting into. And I mentioned it before about this umbrella notion. Well, my first case I tried was a psychiatrist who had an affair with his patient, and that's an adversary proceeding on a claim of non-dischargeability and so on, and followed immediately by a child molester. So that was my introduction, and I'm scratching my head and rhetorically saying, why is this in bankruptcy? Why isn't it someplace else? And of course the answer is certain kinds of debts are not dischargeable in certain chapters, and if somebody else hasn't already made a determination by an adequate burden of proof about the level of conduct that would make it non-dischargeable, then we have to do that. Another one that was fascinating, it's a case called Vivid Image, which was a company that was sued for patent infringement in the district court in Ohio, as was its distributor of its product. And the district court in Ohio had set up a scheduling order that had them getting to a Markman hearing in about 18 months after the filing. Well, the company said, we can't survive with that kind of cloud hanging over our head. So they filed bankruptcy in our district, and I drew the case. And then they filed a declaratory relief action for a determination that there was no violation. And the company that filed the suit in Ohio stipulated to my entering final judgment in that case. I actually had to enjoin the district court in Ohio from going forward as against the distributor, because under patent law, or copy, in this case patent, they could go against the distributor or the provider, and establishing liability against either one creates a problem. So I did that. I was able to rule on the case in a claims classification proceeding. It went up to the BAP, was affirmed, went to the Federal Circuit after that, was summarily affirmed by the Federal Circuit on the same day it was argued, and sent back all before the district court in Ohio was going to have the Markman hearing. So that was unusual. As a company, that what they did was they had a computer system that they developed where you could scan a photograph in, and they would they'd print that photograph onto what they call an edible substrate. It's basically a piece of paper you can eat, and then put it on top of a cake. All of us have seen grocery stores and stuff that advertise the opportunity to do that. Well, this was one of the manufacturers, and the question was whether the system Vivid Image had impinged on the patent that this British company owned. So it was fascinating to get into. The variety of stuff we get to see, the complex stuff, probably the nastiest cases are the family law cases. that come at you. I had an intriguing one where it was the wife who had all the money. They got a divorce. He was allowed $16,000 a month, out of which he was supposed to apply 10 towards community debts. Well, he got the bright idea that he'd file bankruptcy, discharge his liability, thinking he'd continue to get the $16,000. I said no, and appointed a trustee. The wife wound up funding the whole bankruptcy, and that got very complex. We actually just finished it up recently after about 15 years because there were some major tax problems arising, amongst other things, out of sale of a big apartment complex in Texas that was not part of the case to begin with, but got brought in because both the IRS and the Franchise Tax Board were looking back at those years, and so we, went through all of that. That got intriguing. There've been so many over the years, but those are a couple of the ones. There was a developer who got himself into a partnership with this little old lady who owned a big motor inn up in Oceanside, and then he sued her. She counterclaimed and got a $21 million judgment against him. So, sort of like the same situation, he got the bright idea that he'd file bankruptcy and use the bankruptcy as the supersedious bond, pursue the appeal, and outlast her, that she'd probably die before it was over. Well, I said he had a conflict of interest and appointed a trustee. In that case, the trustee was able to settle the claim, sold off some of his properties. This guy filed objections to every single thing. Over 50 appeals filed in that case. Yeah. And finally, we had to set it up in a way so that we confirmed a Chapter 11 plan proposed by the trustee, the Chapter 11 trustee, but that provided that all this stuff was resolved in some way, shape, and form, and that there was a final bar to his ability to sue the trustee. Because he kept suing everybody, including me, on this, and so if it was going to be a situation where, okay, the case is over, but now the trustee's still being sued and the trustee's professionals, how are they going to chase him down and recover their costs of defense? So we set it up in a way, actually the trustee proposed it and I approved it. I didn't have anything to do with setting it up, but in the sense of saying, this has got to be concluded, there's got to be a reserve pot that's going to take care of those kinds of costs so that the trustee and the professionals are not exposed.
Moving away from the court itself, I know you've been active nationally. You are considered the ethics guru, the bankruptcy representative on the National Ethics Committee for some years. Tell me about that.
Oh, that was rewarding, and I'm not sure how I was so fortunate to get it, but in 1995 I was appointed by Chief Justice Rehnquist to the Codes of Conduct Committee. There's one Article III judge from each circuit on the committee, one bankruptcy judge nationally, one magistrate judge nationally, and I got it. I served on that committee. Normally you get a 3-year term, and if you don't mess up too badly, you get another 3-year term. I served 8 years because I was extended by Chief Justice Rehnquist another 2 beyond. And during that, got involved in doing educational programs for the Federal Judicial Center, which I started doing in '97 and am still doing to this day, even though I've been off the committee since '03. And then in '03, just as I was getting ready to leave the committee, the ABA was working on drafting the model code, and I was assigned to be the liaison from the Judicial Conference US to the ABA, spent 3.5 years working with them. As of last week, I'm now the new chair of the Judicial Advisory Committee, the ABA Standing Committee on Ethics and Professional Responsibility. I'm still doing programs. I love the work, and I love that I didn't have to leave it, just put it in a shelf or in a drawer somewhere when in '03 when my time on the committee was up. And it's gotten me overseas. I've been to Russia several times. I've been to Mongolia. I've been to Moldova to work with their judiciaries. And I've hosted delegations from particularly Eastern European countries, Ukraine, the Russian Federation, that kind of thing, including within the last couple months.
Has anything surprised you in your work dealing with ethics?
Sure. And the challenge always is, And the difficult thing to get at, and what our programs are aimed at, is raising sensitivity, because each of us is personally pretty certain about our rectitude. We're pretty confident in the appropriateness of our decisions. What we don't do often enough is take a step back and say, yeah, I'm comfortable with this, but how does it look to somebody else? What does somebody on the outside look like? Justice Kennedy, in a concurring opinion in a case called Liteki, explained it, and I'm paraphrasing, but the gist of it was that when somebody loses, the last reason they look to explain why they lost is the merits. They're always looking for something else. And as he put it, our job is not to give them that excuse. So that's my goal in working on the ethics programs, is just try and raise everybody's sensitivity, try and ask them to take a step back and say, how does this look to somebody else? Because we don't have armies to enforce our decisions. Our ability to accomplish anything useful in the legal arena is dependent upon the willingness of the people of the country, of the states, federal, whichever court it is, to believe in and follow the decisions that we make. I mean, somebody's going to lose in a decision, but if they have confidence in the integrity of the process, confidence that there's no ulterior motive or bias involved in the process, there's a greater likelihood that they're going to at least grudgingly accept it. I don't agree with the decision, but I understand how the judge got there. And that's an important part of how we go about our work, too, is making sure we are able to do that to the people who appear in front of us, is to tell them, I understand where you're coming from, but I have to disagree with you, and here's why I disagree with you. And I look at these precedents, and I add up these facts based upon the evidence presented to me and the burdens that the respective parties have, et cetera. Try and help them understand, because it's so important to the people who come to us. If they get to see us at all, because in many of our cases, they're processed administratively by the trustees and we don't ever see them. That's why when I talk to the staffs and the National Conference of Bankruptcy Clerks and so on, and try and explain to the people, including my own staff, that they are the face and the voice of the court, often for many people with whom that may be their only contact. But when they see us, if they can walk away and say, I was heard, I'm disappointed in the outcome, but I was heard, and I have no reason to say that there was some ulterior motive, then we've done about the best we can do. And that's why I think it's so important, and that's what I try and do with it. One of the things that has been very rewarding to me is when I was in Moldova in '96, one of their judges asked me, well, when did you guys adopt a code of conduct for your judges? And I had no clue. And I came back and started researching, and I put together a lot of information and was asked to present it to the committee. I did. It was an 80-minute presentation going back to the 25th century BC and working forward. Well, and they had it videotaped. The AO's people were not happy with the quality of the videotape, so we reworked the script, and they had me come back and did a video for them that came out in '04. But they've been running it as part of the FJTN education ever since. I mean, 10 times a month kind of thing. They've got it on their streaming video now, and David Sellers, the head of the public affairs group, was out when I did a presentation to some Russian judges, commercial court judges. They've got a code that they're ready to present. And I was able to say to them, look, you're going to have to persuade your colleagues about this, and your colleagues are going to say, well, where do these principles come from? And I'm able to tell you that, go back and look at Deuteronomy and Leviticus in the Old Testament. Let's look at Justinian in Corpus Juris Civilis in 534 AD. Let's look at Maimonides in the 12th century and look at what they're talking about. None of this happened in America. I'm not telling you what we do. I'm talking about principles. We're talking about expectations of people's societies down through time. And so, get me going on the subject.
Okay, I think it's fascinating. Tell me about your experience as chief judge.
Well, as I indicated, it wasn't one I chose. And, You know, it's particularly challenging because when I started out as chief judge, my three colleagues, as I had indicated, were all senior to me and had all been chief. And I was reminded of those expressions about what it's like. You know, it was Gil Merritt, I think it was Chief Judge of the Sixth Circuit, who said, you know, when they hand you the reins, they don't tell you they're not attached to anything. Or Terry Hatter's reported statement about it's like being in charge of the cemetery. You know, there are lots of bodies out there, but nobody's listening. You know, it's like that. I mean, how do you persuade people? And that's what it's about. So it's trying to figure out those kinds of things. It's trying to figure out the balance between the judges and the clerk that has a whole separate administrative office. And one of the challenges has been with the two newer judges who came from private practice experience and weren't used to being part of a bureaucracy. They were part of a law firm where the goal was all support the lawyer. Everything's to support the lawyer in service to the client. In bureaucracies, they got a whole bunch of other stuff. I mean, the clerks have a tremendous amount of responsibility and breadth of responsibility, and learning about that and trying to figure out where I was comfortable versus where I should leave the clerk alone rather than try and learn everything and you know, become a replacement for the clerk or be able to step in an emergency or that kind of stuff. Those kinds of challenges, I've been very fortunate because of the colleagues I have and because we have a small court. I can't imagine what the Central District was like.
I'll tell you one day over for my tie.
Yeah. But so.
And the Ninth Circuit seems to be unique. I mean, I found that when I was chief and throughout my term. Is the Ninth Circuit unique when it deals with its bankruptcy judges?
In my belief, the answer is yes, and I've had the benefit of traveling around the country. I've spoken at judicial conferences of 5 other circuits, you know, on ethics issues and stuff, but spending time with them and see the difference. I mean, I could tell you some stories, but there is no question about it. And let's start with the fact that in '91, I was appointed by the chief bankruptcy judges of our circuit to be their representative to the Judicial Conference Executive Committee. And I went on that committee, and you know, like many places, if you've got people who are willing to do the work, you have a chance to contribute and so on. And I was so fortunate that Lloyd George was chair of the program my first year. He put me right up front, maybe in the moderator for the third day, including introducing Justice O'Connor and so on. So I had to call her, and she gets on the phone in her chambers back in DC, and we talk, that kind of thing. You know, then the next year, Lloyd was chair of the conference, and Bob Coyle was program chair. Again, very friendly to bankruptcy judges. Our circuit generally is. And Bob put me in charge of the program for a day, and I got Janet Reno, I got Bernie Nussbaum, who was White House counsel, and so on. That was a Santa Barbara program. And then the Peter Principle kicked in because I became the first Article 1 in any circuit, as far as I know, but certainly in ours, to become program chair. And during my time on the Conference Executive Committee, we got the council order changed so as to allow bankruptcy judges and magistrate judges to become chair. So, you know, it's been a wonderful experience in that way. And, you know, in terms of our circuit, the interpersonal relationships that you get to build, particularly through conferences like this one, and annually, particularly because we are so far-flung, are wonderful opportunities that carry over. And so I've been very grateful, and I believe from my experience, from what I've seen, we have the best of environments, and if anything else, it would probably make most people jealous.
And I think it should. Peter, thank you so much, and I do hope that you will take the time to do the full oral history. You've had so much experience and so much to tell us and to teach us that we want to get it down on tape.
Well, thank you for the invitation to do that, and I will reflect on it. I mean, it is fun to, you know, although I worry about whether I'm writing my epitaph or something, but...
I've done it. Okay, thank you.
All right, thank you.